Welcome to the debate. Today we are addressing a profoundly consequential intersection of biology, natural law, and our constitutional architecture. We're examining the foundational question of rights and existence itself. Does the biological beginning of human life automatically dictate constitutional personhood under the 14th Amendment, or does legal personhood remain an entirely distinct category? One that the state has the exclusive authority to define, manage, and administer.
Right, and this discourse is grounded entirely in the March 2026 treatise by Zachary David Enfield titled The Perseverance of a Faithful Gavel for the Unborn. It's a text that masterfully weaves together constitutional history, the 2016 biological discovery of the zinc spark, and some incredibly profound philosophical frameworks.
It is a rigorous text, and it demands a rigorous stance. My position today is unyielding. The biological reality of life anchors an unbroken constitutional chain. The right to life is an absolute meta right. It is a structural reality that simply cannot be severed from legal personhood by the state.
And I will be taking the other side, representing the perspective of legal positivism and complex rights balancing. I'll be arguing that while biological science perfectly describes nature, only legal frameworks can resolve competing constitutional rights and define legal categories.
Let's start with the structure the American legal system built for itself. If we look at the 14th Amendment, the text explicitly commands that no state shall deprive any person of life without due process of law. It uses the word person as a given, a reality existing prior to any state definition. And for a long time, there was a scientific debate about when that life begins. But in 2016, researchers at Northwestern University empirically anchored exactly when a biologically distinct human organism comes into existence.
You're talking about the zinc spark.
Exactly. They documented the zinc spark, which is a visible flash of zinc ions observable under fluorescence microscopy at the precise moment of fertilization. There is no ambiguity left. Before that exact microscopic flash, there is no distinct human organism. Immediately after, there is one. Furthermore, John Bingham, the primary author of the 14th Amendment, stated directly on the congressional record that his purpose was to constitutionalize the Declaration of Independence's natural law framework. That is a framework where rights are endowed and unalienable. Life is the meta right. It is the absolute precondition for the exercise of every other right. Liberty, property, the pursuit of happiness, these are all downstream of life.
Okay, I'll grant you the science. The zinc spark is entirely reproducible, peer-reviewed science. A distinct genetic organism begins at fertilization. But jumping from a microscopic flash of light to an absolute constitutional mandate is a massive category error. It fundamentally conflates biology with law. Science determines when biological life begins, absolutely, but the law determines legal personhood.
I completely reject the premise that aligning constitutional protection with biological reality is a category error.
But the law routinely and necessarily separates life and personhood. Think about how we handle corporate personhood for a second. We grant personhood to entities like banks or tech companies that possess absolutely no biological life, enabling them to enter contracts, hold property, and exercise speech rights. Conversely, we navigate complex end-of-life scenarios where biological processes might continue on a ventilator, but legal personhood rights are fundamentally altered or transferred. Personhood is and always has been a legal status administered by the state.
That comparison actually illustrates my point. A corporation is a legal fiction created by the state to facilitate commerce. A living human organism is a pre-political reality. Conflating a state-created legal fiction with a biologically distinct human being is the actual category error here. If a legal framework like legal positivism tries to separate biological life from legal personhood to deny fundamental rights, it's what we call void ab initio. That means it is legally invalid right from the very start. The foundation is rotten.
I wouldn't call a framework that allows a pluralistic society to function rotten.
But look at the mechanism. Defining personhood by evacuating life from it mimics the exact constitutional error of Dred Scott. In that infamous decision, the state defined a class of biologically human organisms out of constitutional protection. Enfield's treatise points out that legal positivism is employing that identical mechanism today. It is structurally unassailable that the state has no authority to employ that mechanism. You cannot separate life from personhood without destroying the subject matter the Constitution was explicitly written to protect.
I understand why you draw that historical parallel, but let's ground this in the operational reality of the law today. A legal system requires workable administrative thresholds. If we rely solely on fertilization, on this zinc spark as the absolute standard for legal personhood, we invite pure administrative chaos.
Administrative difficulty does not invalidate a constitutional right.
But consider the practical reality. What about the natural loss of fertilized eggs before implantation? This occurs frequently in nature. If every single fertilized egg is a constitutional person from the exact second of that zinc spark, how does a state even function? We're talking about the state's obligations becoming impossibly entangled in natural biological processes. The law cannot practically function at that level of microscopic granularity. This is why the treatise's attack on the person-life severance doctrine misses the mark. Severing raw biological facts from state administrative recognition isn't some malicious constitutional fraud. It is a necessary feature of any functioning legal system that has to govern society practically.
I am not convinced by that line of reasoning, because the practical difficulty of implementing a principle never defeats the principle itself. Think about Brown v. Board of Education. Desegregating the American school system was enormously complex. It was highly disruptive and practically, administratively difficult. But none of that defeated the constitutional principle, because the principle was right. Logistics do not dictate fundamental rights.
Desegregating schools didn't require the state to monitor microscopic cellular processes. The scale of entanglement is completely different.
But your specific objection about the natural loss of fertilized eggs conflates natural processes with state action. The 14th Amendment restricts state-authorized deprivation of life. It explicitly commands that no state shall deprive a person of life without due process. It absolutely does not mandate that the state must prevent or investigate every natural death. Your practical objection is answering a question that the Constitution isn't asking.
Even if the state isn't investigating natural loss, declaring full personhood at the zinc spark radically alters the legal landscape for anything the state does regulate.
As it should. Because if we accept this person-life severance doctrine, what are we actually left with? If the state can define personhood without the prerequisite of biological life, personhood becomes nothing more than a license. It simply designates whoever the state currently prefers to recognize, based on administrative convenience. Licenses are things states issue and revoke, like a driver's license. The 14th Amendment was written to protect persons, not licenses. The biology provides the factual predicate, the natural law framework provides the normative bridge, and the constitutional text provides the legal command. You cannot sever the life from the person.
Okay, let's push this to the absolute strongest counterargument, because we cannot ignore the profound constitutional conflict that arises when we actually apply your absolute standard. Let's talk about bodily autonomy and the liberty interest of the pregnant woman.
We can discuss it, but the structural hierarchy remains absolute.
The pregnant woman is an unequivocally established constitutional person. There is no debate there. The 14th Amendment guarantees her liberty. Now, even if we were to grant your premise and legally recognize the unborn organism as a full person from the moment of the zinc spark, a right to life does not historically include the right to use another person's body to sustain that life without consent.
That framing treats them as disconnected strangers, which ignores the biological reality of reproduction. But please continue.
It is a clash of equals. You have two constitutional persons with competing rights. The pregnant woman's liberty interest is a real, deeply rooted 14th Amendment right. The legal system, not just a biological event observed under a microscope, must resolve this genuine conflict. This is not the state arbitrarily deciding who counts as a person, This is the state doing exactly what positive law is designed to do, balancing competing constitutional liberties through democratic deliberation.
I see why you frame it as a balancing test, but I refuse to accept the premise of competing equal rights in this context. It fundamentally misreads the architectural structure of rights. To understand this, we have to look at what Enfield calls the downstream-upstream inversion.
How so?
Life, liberty, and property are not three equal items on a flat, horizontal list. They exist in a strict, unyielding hierarchy. Think of building a house. Life is the foundation. Liberty is the framing. You cannot adjust the framing by dynamiting the foundation. Life is the upstream precondition for every single other right. A subject must be alive to exercise liberty. Therefore, liberty is downstream of life.
But the pregnant woman already has the foundation. She has life. And therefore, she has the liberty to decide what happens to her own body.
But when you invoke the mother's liberty interest to justify the termination of the unborn's life, you are committing a profound structural error. You are using a downstream right, the mother's liberty, to completely revoke the upstream precondition, the unborn's life. This destroys the structural relationship of rights entirely. You cannot use an instrument that presupposes life to eliminate the life that a second organism requires to ever hold any rights at all.
You are elevating the unborn's right to life so high that it completely erases the woman's liberty. Positive law doesn't allow one right to utterly obliterate another without balancing.
Because the meta-right structure does not permit balancing life against liberty when the result is the cessation of life. If you establish the legal principle that a downstream right can override an upstream precondition, that principle does not come with a directional constraint. Think about the precedent. If liberty can revoke life, the state can use any liberty interest to justify taking any life. The framework that licenses this move establishes a mechanism by which any deprivation of life can be justified. I do not deny the mother's liberty interest, but the upstream precondition of life cannot be eliminated by a downstream right without collapsing the entire architectural logic of the Constitution.
This specific meta-right structure relies incredibly heavily on the natural law framework of the Declaration of Independence. You are invoking concepts like nature's God and unalienable rights endowed by a creator.
I am invoking the explicit intent of John Bingham, who wrote the 14th Amendment to constitutionalize those exact concepts.
While that is historically and philosophically rich, importing this directly into modern constitutional interpretation as an absolute mandate violates the Establishment Clause of the First Amendment. The United States is not a theocracy. The Establishment Clause explicitly prohibits the government from making any law respecting an establishment of religion.
That is a fundamental misunderstanding of both natural law and the Establishment Clause.
Is it? Legal positivism, where the state defines law neutrally based on enacted statutes and democratic consensus, is necessary precisely to prevent the state from enforcing a specific theological or metaphysical framework on a pluralistic society. You are asking the state to adopt a natural law framework that is inherently tied to a theological premise of a creator. Positivism protects citizens by ensuring that the law is whatever is validly enacted by the people, rather than what a specific moral or religious tradition claims it ought to be. It achieves neutrality by separating law from sectarian morality.
I am actually very glad you brought up the Establishment Clause, because we need to apply the Supreme Court's own standards to this claim of positivist neutrality. Let us look at the functional test for religion established by the Supreme Court in cases like Welsh v. United States and Torcaza v. Watkins.
Those cases were about conscientious objectors and religious tests for office.
Exactly. And in deciding them, the court had to define what constitutes a religion under the First Amendment. They established a functional test. A belief system qualifies as religious for First Amendment purposes if it occupies a place parallel to that filled by the orthodox belief in God. In other words, if it functions as the ultimate authority governing the holder's life and provides a comprehensive account of ultimate reality, it functions as a religion legally.
And you are going to argue that a secular legal theory is a religion.
I am arguing that legal positivism, when enforced as the exclusive framework of American constitutional law, answers yes to every single criterion of an established religion under the court's own test.
That is quite a leap.
Look at the mechanics. Positivism provides the governing account of ultimate reality. It declares that rights only exist if the state extends them. It occupies the place of final authority, answering to nothing above itself, not even biological reality. It imposes mandatory adherence on all citizens, and crucially, it completely excludes competing accounts of ultimate authority, such as natural law, as inadmissible. By using the Establishment Clause to silence natural law, positivism has achieved the exact opposite of neutrality. It has established its own secular religion. It elevates the state to the role of the creator. It prefers the one creed that denies what all other traditions affirm.
Incredibly expansive reading of the Establishment Clause, effectively turning it against the very secular legal system it helped build. To label legal positivism a religion simply because it relies on human enacted law rather than transcendent moral claims stretches the Welsh functional test far beyond its breaking point.
It is exactly how the test functions.
Positivism does not claim to answer ultimate questions of the universe. It doesn't tell you the meaning of life. It simply provides a procedural methodology for identifying what the law is in a pluralistic society where people fundamentally disagree on those ultimate questions. It describes how the legal system works without dictating what citizens must value in their private lives.
But it does dictate ultimate reality when it decides who qualifies as a person. And furthermore, natural law is not a sectarian theological premise as you claim. Enfield's treatise details what he calls the universal witness.
Meaning?
Meaning that 9 independent civilizational traditions converge on the inherent worth of human life from its biological origin. We are talking about Judaism, Christianity, Islam, Hinduism, Buddhism, the Ubuntu philosophy in Africa, the Lakota tradition in North America. They all recognize this.
Those are all spiritual or religious traditions. You're proving my point about the Establishment Clause.
But even if you strip away all theology, purely secular, rationalist frameworks arrive at the exact same place. Take Immanuel Kant's categorical imperative. It is derived from pure reason, not theology, and it explicitly forbids treating a human being merely as a means to an end. Or look at John Rawls's veil of ignorance.
The thought experiment about designing a just society?
Exactly. Rawls asks us to imagine designing a society without knowing what our position in that society will be. Under the veil of ignorance, rational agents would universally design a system protecting life from its earliest documented beginning, because no rational actor would agree to a system that allows their life to be terminated before they are even born. The zinc spark is simply the empirical documentation of what this universal witness has always pointed to. Natural law is the only genuinely non-preferential framework available. It is the convergent conclusion of human civilization, completely destroying the claim that recognizing the unborn violates the Establishment Clause.
But a legal system cannot simply defer to a philosophical universal witness when faced with the agonizingly complex, real-world conflicts of a modern society. Kant and Rawls are brilliant philosophers, but their frameworks do not automatically resolve the practical tension between the established liberty rights of a pregnant woman and the biological reality of a fertilized egg. By insisting that biological life universally and immediately dictates constitutional personhood without any state mediation, you bypass the democratic deliberation necessary for a functioning republic. Science gives us data, it gives us the zinc spark, but the leap to an absolute legal mandate ignores the necessary complexities of positive law.
And I return to my core stance. The American legal architecture is built on an unbroken chain. It begins with the empirical biological reality of the zinc spark. It moves to the natural law recognition of inherent human worth, acknowledged in the Declaration of Independence as an unalienable endowment. It is then constitutionalized by John Bingham's documented intent into the 14th Amendment, which commands that no state shall deprive any person of life. This chain absolutely forbids the state from treating personhood as a malleable license it can define out of existence. Life is the meta right. You cannot sever the life from the person, and you cannot use a downstream liberty to revoke an upstream precondition. The structural reality is absolute and unassailable.
And I maintain my stance that while science certainly defines when biological life begins, the law must define legal personhood. Conflating the two ignores the essential role of the state in administering rights and resolving genuine constitutional conflicts, particularly regarding bodily autonomy and liberty. The leap from microscopic biology to an uncompromising legal mandate bypasses the necessary, albeit messy, complexities of positive law and democratic consensus.
The profound tension between our perspectives remains clear. We are fundamentally divided on the deepest question of law, whether rights are pre-political endowments anchored in nature and empirical reality, or whether they are legal constructs managed and defined by the authority of the state.
It is a tension that touches the very foundation of how we govern ourselves.
Testing the bedrock of our legal architecture is essential for any society that claims to value justice. We encourage our listeners to explore Zachary David Enfield's deeply integrated source material, The Perseverance of a Faithful Gavel for the Unborn, to engage with this integration of science, history, and philosophy themselves.
Welcome to the debate. Today we are tackling a massive foundational question. We are looking at where exactly biological science ends and constitutional law begins. Specifically, we're diving into a concept called the person-life severance doctrine, and really digging into the incredibly high-stakes question of whether the state possesses any legitimate authority to define legal personhood independently of biological reality.
Yeah, and this whole discussion emerges directly from a really fascinating, highly comprehensive legal, philosophical, and scientific treatise. The source material analyzes the 14th Amendment, the historical framework of natural law, and this incredible empirical phenomenon known as the zinc spark. It's a text that doesn't just ask, basic policy questions. It challenges the absolute structural foundations of how our legal system addresses human life. It demands rigorous scrutiny.
It absolutely does. And to lay our cards on the table right at the top, I will be arguing that the science is settled here. The scientific documentation of life beginning at fertilization absolutely mandates constitutional personhood under the 14th Amendment's natural law foundation. And because of that, any attempt by the state to separate life from personhood is structurally void. I will not concede any ground on that.
Right, and I come at it from a slightly different angle. I take the position that biological life and legal personhood belong to fundamentally distinct domains. Yes, biology is biology, but the law requires practical frameworks. Positive law, meaning the law as it is actually written and enacted by humans, has to be used to resolve competing constitutional rights, especially in a complex, pluralistic society like ours.
Well, let's just jump right into the foundation of this, because I want to be completely unequivocal from the start. The empirical anchor of this entire discussion is absolute. In 2016, researchers at Northwestern University documented something truly remarkable: the zinc spark. And for anyone unfamiliar, this isn't a metaphor or some poetic way of describing conception. It is a literal, visible, measurable flash of zinc ions at the precise microscopic moment of human fertilization. It is published, reproducible science. It proves beyond any scientific doubt that a biologically distinct human organism begins right there. That is the biological reality.
Mm-hmm. And just to jump in for the listener, it truly is an incredible piece of biology. I readily concede the biological reality of the zinc spark. The science is undeniable that a new, distinct human organism begins at fertilization. I'm not disputing the biology at all.
And because that biology is undeniable, the constitutional anchor is equally absolute. The 14th Amendment commands equal protection for persons. If we look at the heavily documented legislative intent of the amendment's primary author, John Bingham, he explicitly constitutionalized the Declaration of Independence's natural law framework. We are talking about creator-endowed, unalienable rights.
But this is where we have to
Delineate our domains? I know that's the argument, but I am not convinced by that line of reasoning because separating those domains destroys the right itself. I maintain firmly that severing the legal category of person from the biological reality of life replaces the amendment's actual subject with a state-issued, revocable permission slip.
The founders heavily utilized Sir William Blackstone's formulation of law, which says that any positive law violating this natural law foundation is strictly void ab initio.
Right.
In everyday terms, void ab initio means it's completely invalid from the very second it was written, like a contract signed in disappearing ink. It offers zero legal shield. The biological person is the legal person. There is no separation, and the state has absolutely no authority to invent one.
That is a very compelling argument. But have you considered that science and law simply have different jobs? I mean, science determines biology, whereas the legal system determines legal status. The distinction between biological life and legal personhood isn't some rogue theory you can just dismiss. It is a foundational, structural feature of our entire jurisprudence. Think about it. We extend legal personhood to corporations. A corporation obviously has no biological life, no DNA, no zinc spark.
Yeah, but
Conversely, we define personhood practically for humans at thresholds like viability or birth, depending on the legal context. This isn't some malicious erasure of natural law. It is just how a complex, functioning democratic society operates.
I hear your appeal to practicality. I really do. But I must absolutely reject the premise that practicality can ever override a constitutional command.
It's not just about practicality, though. It's about balancing genuine, competing constitutional rights. In this specific context, we have to balance a mother's deeply rooted 14th Amendment liberty interest against the biological life of the unborn. You cannot simply collapse law into biology without stripping the democratic society of its ability to weigh these massive competing interests.
Let's address your core assumption directly, because I refuse to yield an inch of ground to that balancing argument. You are essentially arguing that moving from a biological event, the zinc spark, to a legal conclusion of personhood is a philosophical category error. You believe science describes what is, while the law decides what counts. But the 14th Amendment does not authorize the state to decide what a person is. It takes person as a pre-existing given, a biological reality, and commands the state to protect it. The category error is actually entirely on the side of legal positivism.
How so? The law has always translated biological reality into policy through the drawing of lines. If every fertilized egg that produces a zinc spark is automatically granted the full, unmitigated legal status of a 14th Amendment person, the legal and administrative chaos would be unfathomable. Think about the rates of natural embryo loss alone. The state has to interact with its citizens through manageable legal categories. It is a necessary distinction.
It is an artificial distinction, designed entirely to evade a constitutional duty. When you argue that the state gets to decide what counts, you are ignoring what the source material correctly terms the universal witness.
The universal witness being the philosophical consensus?
Exactly. It's not just a niche legal theory. 9 independent civilizational traditions converge on the inherent worth of human life from its biological origin. Whether you're looking at Kant's categorical imperative, which demands we treat humanity as an end in itself, or Rawls' veil of ignorance, or the Ubuntu philosophy from Southern Africa, or the Islamic fitra, Buddhist precepts, and the Judeo-Christian tradition. These aren't just a grocery list of ideas. They all arrive at the exact same conclusion, completely independently. The entity that begins at the biological origin has inherent worth. The zinc spark is simply the empirical confirmation, the biological timestamp of what natural law has always known. I understand the philosophical convergence. I do. But philosophy doesn't write state statutes. But it informs what those statutes are allowed to do. Allowing the state to define personhood by evacuation, meaning emptying the word person of its living biological referent, mirrors the exact mechanism of the Dred Scott decision. You are excluding a biologically human organism from legal protection based entirely on administrative preference. That is not drawing a pragmatic line for societal function. That is constitutional fraud.
I'm sorry, but I just don't buy that. Let me tell you why. The Dred Scott comparison, while rhetorically devastating, conflates a malicious, racially motivated exclusion with a practical, developmental threshold. The state isn't acting with animus toward the unborn when it creates legal thresholds. It is acting to resolve an inescapable conflict of rights. We cannot govern a nation of hundreds of millions of people through pure philosophical abstraction.
It's not an abstraction, it's biology.
But the conflict between a mother and the unborn is incredibly genuine. The pregnant woman holds a heavily protected 14th Amendment liberty interest to make intimate decisions about her own body and future. Positive law is the necessary democratic mechanism to weigh and balance these two competing rights. When you completely fuse the biological life of a microscopic entity with absolute legal personhood, you entirely erase the mother's liberty interest from the equation. You leave the law with no tools to manage the physical reality of pregnancy.
I do not erase her liberty interest at all. I place it in its correct constitutional and logical structure. I must dismantle this balancing framework entirely because it relies on a fundamental downstream and upstream inversion.
What do you mean by an inversion?
Let's look at the rights protected by the 14th Amendment: life, liberty, and property. Legal positivism treats these like a flat, horizontal list where we simply weigh them on a judicial scale depending on the prevailing political winds. But they are not horizontal. They are a strict, unidirectional hierarchy. Think of it like building a house. Life is the foundation, the upstream precondition. Liberty and property are the walls and the roof, the downstream rights. You cannot exercise liberty if you have been deprived of life. Therefore, you cannot use a downstream right, like the mother's liberty, to revoke the upstream precondition of the unborn's life. If you tear up the foundation, you cannot expect the walls to stay standing. You destroy the structural relationship that makes the downstream right coherent in the first place.
That's an interesting point, though I would frame it differently. By declaring life an absolute upstream precondition that overrides all competing liberty interests, you are essentially saying the law must be blind to biological dependency.
I'm not saying it's blind.
But practically it is. The fetus's life is entirely dependent on the mother's bodily liberty. There is a shared physical space. The law has to account for that physical reality, which is why a balancing test is not an inversion of rights, but a sober recognition of biological dependency. You can't separate the upstream right from the physical vessel it relies on.
Dependency does not negate personhood. Under natural law, dependency generates an obligation of care, not a license to eliminate. But let me press this further, because there is a lethal consequence to your framework that you cannot escape, and the source material lays this out brilliantly. It is the kamikaze payload of legal positivism.
The kamikaze payload?
Yes, think about what this actually means for the listener. If your framework allows state authority to revoke the unborn's life to serve a liberty interest, it establishes a universal principle. A downstream right can officially override an upstream precondition. Furthermore, if personhood is just a state-granted license based on administrative convenience, then you have removed the floor protecting everyone. If the state can sever personhood from biological life for the unborn, it means the mother's liberty, and indeed her own life, is merely a revocable permission granted by the state. It's like turning constitutional rights into a subscription service that the government can cancel whenever it decides you no longer meet their criteria for personhood. You are defending a system that ultimately protects no one. You have detonated the floor beneath your own feet and called it a pragmatic balancing of rights.
I see the logical trap you are pointing out, but I view positivism as a shield against precisely the kind of absolutism you are advocating. You paint legal positivism as a tool of tyranny that strips away fundamental rights. I view it as a neutral, procedural methodology that keeps our legal system functional and democratic. It specifically prevents the imposition of sectarian theology or rigid moral absolutism on a highly diverse secular populace. By asserting that the law is what is enacted by human beings, we rely on democratic consensus. We don't force Kantian deontology or specific theological interpretations onto the public. We let the voters and the legislature decide where those lines are drawn. That is the very essence of the Establishment Clause, keeping religious or moral absolutism out of state enforcement and maintaining a neutral public square.
I see why you think that, but let me give you a different perspective, one grounded entirely in the Supreme Court's own jurisprudence. Your defense of positivism as neutral is exactly where the framework completely convicts itself. Legal positivism is not neutral at all. In fact, it operates as an unconstitutional established religion under the Supreme Court's own functional tests. Specifically, if you look at the rulings in Welsh v. United States and Torcaso v. Watkins.
Calling a procedural legal philosophy a religion stretches the definition of the word way beyond its utility. It is a framework for identifying valid law, not a system of spiritual worship. How can you equate a secular legislative process with an established church?
Because the Supreme Court's functional test does not require spiritual worship or belief in a deity to define a religion for First Amendment purposes. The court asks if a given belief system occupies a place in the lives of its adherents parallel to that filled by orthodox belief in God. So let us look at the evidence objectively. Does positivism provide a governing account of ultimate reality? Yes, it dictates that rights come solely from the state and that the creator referenced in the Declaration has zero legal standing. Does it occupy the place of final authority? Yes, it claims absolute final authority over who is and isn't a person. Does it impose mandatory adherence? Yes, it is enforced by the full coercive apparatus of the state. And does it explicitly exclude competing accounts? Absolutely.
But excluding natural law isn't an establishment of a state religion. It's the maintenance of a secular legal order. If we allow natural law arguments based on nature's God or inherent creator-endowed rights to dictate constitutional interpretation, we are inherently favoring belief systems that accept those premises over those that do not. That is exactly what the First Amendment forbids. It forbids the state from taking a theological side.
That is the ultimate inversion of the truth. Natural law is, in fact, the only genuinely non-preferential framework available to us. Why? Because as we discussed with the universal witness, it is the convergent conclusion of all major traditions, secular and religious alike. It is the one thing everyone actually agrees on when they aren't trying to reverse engineer a legal outcome. Excluding natural law doesn't achieve neutrality. It achieves the maximum preference of the one single creed, legal positivism, that denies what every other tradition on earth affirms. By using the Establishment Clause to ban natural law, the state has actually established the Church of State Sovereignty. By establishing positivism as the exclusive framework, the state has violated the very Establishment Clause it claims to be enforcing. There is no neutrality in declaring that the biological beginning of a human organism doesn't count simply because the state administrative apparatus says it doesn't.
Even if I were to grant that positivism functions similarly to a comprehensive worldview, which is a fascinating way to apply the Supreme Court's functional test, the alternative you are proposing brings us right back to the practical impossibility of enforcement. If we interpret the 14th Amendment strictly through the lens of a natural law framework that recognizes absolute legal personhood at the microscopic flash of the zinc spark, we would be fundamentally altering the legal status of every pregnant woman in the country. We would be subordinating her liberty to a microscopic entity based on a philosophical interpretation of biological data. The law must serve the living, breathing, fully actualized citizens of the Republic. Positivism allows us to do that by separating empirical biology from the rights-bearing legal status of personhood.
And I will not concede a single inch of ground on that premise. The law must serve all persons. The moment you introduce a threshold of fully actualized, you have completely abandoned the 14th Amendment and returned to the exact logic that allowed historical atrocities. The unbroken chain presented in the source material is entirely visible and logically sound.
Walk through that chain one more time.
It runs from the undeniable empirical reality of the zinc spark to the universal witness of natural law, to the Declaration of Independence, straight into the 14th Amendment through John Bingham's documented legislative intent. This chain absolutely forbids the state from defining human personhood as a revocable permission. The person-life severance doctrine is logically self-defeating and constitutionally void. If the state can evacuate the word person of its living biological referent, then we have nothing but the state. And a state unconstrained by natural law is a state that can and eventually will revoke the rights of anyone it deems less than fully actualized.
Well, to summarize my position in light of this really intense discussion, I completely respect the logical coherence of the natural law framework you've presented. The biological markers, such as the zinc spark, are undeniable empirical facts that show us exactly when a new human organism begins. I don't dispute the science. However, maintaining a complex, pluralistic legal system requires the capacity to separate empirical biological descriptions from constitutional legal statuses. We must have the ability to democratically balance competing fundamental rights, like a mother's deeply held liberty interests and the developmental life of the unborn. Legal positivism and the separation of life from personhood is not an act of malice or a covert state religion. It is the necessary pragmatic machinery of a functioning democracy trying to navigate an impossibly complex moral and physical landscape.
And I summarize my position without concession. The biological life is the legal person, period. The meta right of life is the foundation of the house. It cannot be subordinated to downstream liberty interests without destroying the foundation of all rights. The state's attempts to sever personhood from life is not a neutral democratic compromise. It is the establishment of a secular theology that violates the First Amendment, nullifies the equal protection of the 14th Amendment, and strips the unalienable rights from the most vulnerable among us. The law attempting to do so is void ab initio.
We have certainly highlighted a profound and likely unresolved tension today. We are really looking at two fundamentally different ways to view the United States Constitution. One views it as a strict, unyielding management agreement of pre-existing natural rights. The other views it as a procedural framework designed for positive law, practical application, and democratic resolution.
The tension is very real, and it demands that we reflect deeply on the foundational roots of our legal and moral architecture. We simply cannot afford to ignore the consequences of how we define humanity itself.
I agree. It is a subject that requires intense scrutiny, and there is certainly much more to explore within these arguments and the source material itself. We leave it to you, the listener, to weigh the evidence, examine the frameworks we've discussed today, and form your own conclusions.
Thank you for joining us on The Debate.